recording. Okay, so this week we've got two discrete topics. In my opinion, the more important of the two is privative clauses, because they fundamentally affect the nature of the power of review, and specifically judicial review, and freedom of information is more of a administrative type resource, if you like. It's important as well, in the sense that it can be a very useful tool as a practitioner, or even as an individual citizen who is interested in discovering public information which is being held by them, as you'll have all seen, and also correcting public information held by agencies. An important tool, but in the context of overall administrative law of the two subjects, it is my view that privative clauses are the more important for you to focus on. I can tell you that to the extent that they'll be examinable, freedom of information would play a very minor role, or form a very minor component of any examinable material, and would be limited, I think, to you being able to identify 2 or 3 of the key sections which provide rights and confirm the nature of the power and the power to request documents, and to the extent that you might use that sort of information in an exam, I suspect that simply citing that as a discovery type tool would be as far as I would expect a student to be able to take it. So what I mean by that is, assume for a moment that you've got a problem question, and the problem question is that a client or a potential client has come in the door and they've got a specific issue involving a government agency. Let's say a government agency is exercising certain powers, and all they can give you is maybe a couple of letters which talk about decisions that have been made or rights that have been affected. One of the jobs of a lawyer is to then go on and identify evidence to get to the bottom of what's going on. So you can imagine that your average layperson confronted with a problem of judicial that fundamentally is going to require some degree of judicial review is going to be overwhelmed about what to do. I mean, how do I battle against bureaucracy? Your job, of course, as the lawyer is to look at it, to look at the problem, and to be able to say, okay, this is an exercise of executive power through administrative decision making. It affects this particular person, and it affects this particular person by impacting on their rights. And in order to be able to assist them by way of trying to restrain unlawful use of power, for instance, I'm going to need some documents, some evidence that point to the excessive use of government power, or the unlawful use of government power, executive power, whatever the case might be. And I'm going to have to get to the bottom of the evidentiary position. And so freedom of information is one potential avenue. So other avenues, of course, would be to file a summons and then to seek some form of discovery, or to get leave if the case requires it. So depending on which jurisdiction you go to, the rules for issuing subpoenas are different. In some jurisdictions you require leave, in other jurisdictions you can issue subpoenas as of right. that's another tool, but that of course requires you to have started proceedings before you actually issue a subpoena. In some cases, your client might be impecunious. In a lot of cases, they may simply not have the sorts of significant financial resources that litigating a case like this would take, and I'd imagine in most cases an invoice of $20,000 is the bare minimum by the time you actually run a case at trial. And, you know, if you've got counsel and you've had to prepare the case, drafting a summons, drafting supporting affidavits, the like is an expensive process, and so simply getting a case started is probably going to cost, you know, in the order of $5,000, and that's going to probably be more than the option of not starting a case but filing a Freedom of Information application in order to try and get at the various records which might assist you determine the various matters that one needs to when prosecuting a judicial review application. So so far as the freedom of to sum up, the Freedom of Information Act is one that's very important. You should all be familiar with at least that summarised version I've provided you in the overheads. The better students will be familiar with the entirety of the notes and be able to give a fairly strong explanation of how the Freedom of Information Act might provide you with a tool to explore the sorts of issues that will arise in a judicial review problem. And that's probably as far as I would expect you to be able to take it for the purposes of this course. Now, does anyone have any questions on the Freedom of Information Act? Is sort of fairly self-explanatory, but some of you might have questions. If we deal with that part of the course first, that might be easiest, and then we can move on to privative clauses. Does anyone have any contributions they want to make about freedom of information or questions to us?
Yeah, Brett, I've just got a comment on this, that having been through this in the notes, it seems that it's more honoured in the breach than in the observance, because there are so many ways in which they don't have to give information. There are so many exceptions. You wonder how on earth anyone does actually get anything they've asked.
By which do you mean? Do you want to give me some examples, John?
We've got a whole list here. It says, start off legal right of access, and then there's an awful lot of exceptions that seem to be brought up.
Yeah.
There's the exceptions from to protect the workings of government, to protect third-party interests, and to uphold other recognised legal interests. Now, other legal interests, you know, that's just so open-ended. It makes you wonder if you can get anything at all.
Well, don't forget, I mean, some of that is right. Those categories are drafted broadly so that they can be a catch-all. John, have you listened to my lecture about the sorts of issues which would come up in respect of each of those categories?
Yes, yes.
Okay. So in terms of other legal interests, one example might be, for example, legally, professionally privileged documents.
Yes, yes.
Now that would be an obvious, and I think most people would say a fair application of a exception, because, you know, for all manner of reasons, government might hold documents which are legally, professionally privileged or commercially sensitive, so commercial in confidence doctrine might apply, and third parties who don't really need access to that document, the sort of document, could be protected. Could be precluded from having access to them. But where you can demonstrate that you've got a bona fide reason for it, you can generally get the tribunals to come round. Now, my first experience, somebody's got their speaker on, you, John, I think. My first experience with freedom of information was as a solicitor. I was probably only a couple of years, maybe 2 or 3 years post-admission. You'll be able to find the case, for those of you who are interested, in the New South Wales Administrative Decisions Tribunal, as it then was, now NCAT. But the party's name was, my client's name was ELOS, E-L-O-S-S, and it was against the New South Wales Police. And the circumstances were that my client said his property had been damaged and he'd made a complaint to the police about it, and they had basically covered it up. Now, I turned up at the Administrative Decisions Tribunal against the solicitor from the Crown Solicitor's Office, who, in classic style, was full of bluff and bluster, telling me how there was no way we were ever going to get the documents, and you know, the whole application was hopeless, and, you know, trash talk like you wouldn't believe. And what eventually transpired, if you have a look at that decision, was that we got access to the documents, and the tribunal member quite rightly took a broad application, took a broad and principled approach to the provisions, and there was actually an appeal decision. The Crown actually, after they were ordered to disclose the document, appealed and lost. So that's one example where you can see the sort of law enforcement and security services trying to use the exceptions in the Freedom of Information Act to you know, potentially cover up wrongdoing, and the tribunals tend to take a fairly circumspect approach to that. A lot of it is how you go about drafting it. But there's an example there. So the exceptions don't apply as a matter of course. There will be, that is, by which I mean, there has to be a bona fide basis for it, and if they're trying to be misused for something which is inconsistent with the public interest, then you won't always have, or the government might rarely have success relying upon them to resist a proper application. But they, by the same token, they have legitimate application as well. I mean, you can imagine that one of the things we don't want is foreign nationals coming to Australia making applications to our security services for documents which they don't need, and which, if released, might actually harm the welfare of the body corporate or the populace as a whole. And so you've got to have these exceptions. Where the issue, where the real issue lies generally is whether they're properly applied, or properly invoked by the government in the first place, and then whether or not they can actually be properly applied to the factual circumstances. Now, to the extent that, as I said a bit earlier, this aspect of the course might actually arise in an exam, it won't be I wouldn't expect it to be a case of, you know, a person wanting to get documents from a security service. You know, the core of this course is about teaching you how judicial review and administrative law generally applies in a civil context, you know, to control the sorts of government action which you would commonly find clients experiencing. So be aware that they're there for the purposes of the course, but don't get too hung up on their application.
So, yeah, I was just going to say, but so how does this sit alongside the Privacy Act?
Well, in New South Wales, the Act has actually changed. It's no longer the Freedom of Information Act. It's now the Government Information, I think, Privacy and Protection Act. And so there's a balance. So one of the reasons that you have these broad categories of exceptions is because there is obviously a tug of war between the notion of open access to information and the ability to participate on an informed basis in your democracy, and on the other hand, the individual right to privacy. So government agencies obviously hold information on all of us, and some of it's wrong, some of it's malicious, some of it might be correct, but not a matter which is of the public interest. And there's, in the authorities, you'll constantly see a distinction being drawn between what is in the public interest, so that is what is of concern to us as a community as a whole, and what is of the interest to the public. So just because it might be juicy or salacious or might be able to sell some newspapers doesn't mean that it's necessarily in the public interest. And if it is personal information of a private nature, then those exceptions will come in to hopefully protect it and prevent general access to it by people who really don't need it. So it's a good example of the privacy principle is a good example of where these exceptions should be properly applied. And in a practical sense, what happens is government agencies receive applications for information, and if it's of a private nature about an individual citizen, the Freedom of Information or Access to Information Officer, the variously described, in short, the public official who is responsible within a particular department for processing these applications, will write to the individual to whom the information relates, saying, we've had a request for this particular information, do you consent to its release? You probably have a right to object under these provisions, please let us know your position. Now your average Joe Blow is going to say, I don't think it's anyone's business what the records of the health department's not a good example because it has its own set of privacy principles, but let's say, for example, the Department of Education might get a request for what courses a specific person has done and a copy of their transcript. Now that's private information that a person should generally have the right only to disclose to those people that they choose to, such as a potential employer, and you would expect that sort of person to invoke the privacy exception. Now it might be a different state of affairs, for example, for a politician who is putting themselves forward as suitable for public office on the basis that they have a solid education and that they've performed well in their education, etc. And in those sorts of circumstances, you might see a private individual waive the right to privacy. So they might write back to the bureaucrat who sent them a letter saying, look, I'm a person who holds public office and I have no concerns about that transcript being released. Anybody else?
Yeah, Brett.
Who's that?
Anthony.
Yeah, go on, Anthony.
How do you get information released if when you put in, say for argument's sake, you put in an application for freedom of information or right to information, whatever it is, if the people you want the information about, they're in a sort of a fraudulent cover-up about something, how do you get the information if they're the ones that actually have they're the ones that actually say yes or no whether it gets released, the information gets released?
Yep, that's a great question. Now, the short answer is that you go to the government department who holds the information and you file a Freedom of Information application asking for the records that you're after, and the internal staff member responsible processes the application, and the Act actually lays out, as you'll see, the requirements for how to process these applications. So there's usually a presumption that the documents will be released, and where a bureaucrat processing this sort of application refuses to release them, they're required to give reasons. Now, this is an example of where merits review arises. So the case I'm referring you to as an example of one I was involved in was one involving the New South Wales Police. Now, they didn't want us getting access to their investigation records because to the trained eye, they were likely to point in the direction of a cover-up. So my client said, and to a great extent I ultimately agreed, if for no other reason than the way that they conducted the subsequent proceedings. Now, they predictably refused to provide the documents and cited all manner of exceptions in the response to the Freedom of Information application which we lodged. And what the Act then says is that where that happens, you've got a right of review, and that review is by way of merits review to an administrative tribunal. So the tribunal then in New South Wales was the Administrative Decisions Tribunal, which is sort of like was then the New South Wales equivalent of the Administrative Appeals Tribunal. It's now called MCAT because all of the states are pretty much now calling them the New South Wales, Queensland or Victorian Administrative Tribunal. And we then argued the toss there, and we argued it on principle. So we said, look, we've got a bona fide interest. These documents relate to a complaint we made and will tell us, hopefully, whether or not that complaint was properly investigated or not. And we say, on a proper application of the principles in the Freedom of Information Act, these documents should be released. They come along and, well, they send the Crown Solicitor along who says, I can't remember exactly what they argued, it was something specious, you can find it in the judgment, and the tribunal rightfully said, effectively, this is nonsense, these documents should be released. They then appealed against that decision. Mind you, there was a little event I should interpolate. They refused pretty much all and sundry. They were not going to give us anything. Then on the eve of the application, they gave us 90% of what we wanted and held back 10% on the hope that that would appease us. It didn't. We went along and we said the fact that they've given us now 90% shows that they never had a proper basis for refusing 90% of what they refused to give us, and we don't agree nor believe that the remaining 10% can be properly justified either, and the fact that they've released these documents tends to point in that direction, and the tribunal agreed. So have a look at that case. It's one which will give you an example of an agency. The police is a bureaucracy like any other, except that it's different to every other. It has its own culture. It's internal security by nature. Law enforcement is an internal security service. So security services, so external security services like ASIO and ASIS, etc., they're even one step further in towards the exceptions. They're much harder to get documents out of, but law enforcement is a good example because if you can get these documents out of law enforcement, then you can get them out of agencies which are less about internal security and more about just government administration. That was probably quite a long answer, but hopefully it demonstrates the point. Anyone else? The name of that case, Jolene, was the party, my client was LAWS, E-L-O-S-S, and the respondent party was the New South Wales Police. I think it was like a 2008, 2009 decision, might even have been as late as 2010. But if you sort of put parties' names in, you should be able to find it, and it'll give you an example of the process. So it says when an application was filed, why we filed the application, what was refused, what was released, what was argued, and it was merits review. So freedom of information is good in an administrative context because it demonstrates where merits review comes in. So we've focused a lot on judicial review so far, particularly in your assignments, and a lot of the course sort of weeks 1, 2, 4, 5, 6, 7, 8, 9, are all 10 are all sort of very strongly geared to judicial review, which is important because it might tell you about how much judicial review and the grounds of judicial review might feature in an exam. And how much study you should devote to how you conduct judicial review and the sorts of problems that you might confront. And the other part is merits review. So We'll touch more on the exam implications next week, but for present purposes, probably what you need to know is that if you get a client and they've got a particular problem and it involves a government agency, one of your options are this freedom of information as a tool. What does the freedom of information say about your right to access information? How do you do it? What are the exceptions? If you're knocked back, what sort of relief are you after? So you need to be able to say, well, you know, there is provision for merits review, and you'd be able to say some key things about how merits review works. And when you get a client that comes in with a particular problem, always remember that you may not be just running one set of proceedings. The rule generally is that if matters can be litigated in a single set of proceedings, they should be. So you can't go to multiple courts and file multiple complaints about the same thing, or the same dispute. But a client might come in with a particular problem, and you know that ultimately to undo that particular damage or harm that's been caused to them, you need to go and conduct judicial review proceedings. But before you get there, you need evidence. So maybe one of the tools is to file a freedom of information application with the department. If they knock it back, you might have to conduct some merits review proceedings in a tribunal. And once, hopefully, you win those proceedings, if it becomes necessary to actually fight them, you'll get documents. Those documents will tell you about the strengths and weaknesses of your case, what the department may not be able to fight you on, that is, what the records might put beyond the pale as obviously and demonstrably true, and what issues you'll need to actually bring evidence forward to prove other aspects of. So, for instance, damage to your client, range of different things. And then once you've done that, then you might be ready to file your summons seeking judicial review. So that's freedom of information in a nutshell. Anyone else got any questions on freedom of information before we move to privative clauses, which I think is the more important part for you all to focus on? Okay. There's no other. Jimmy, have you got any questions? Your typing thing, I think, your icon is on. Not really, thanks. If you do, now's your opportunity. Spit it out. While Jimmy and maybe Peter are formulating questions that they've got, does anyone want to raise issues in relation to privative clauses? How have you, sorry Peter, you've written one. Yeah, I saw that. That's in relation to privative clauses. I haven't ignored that, but what I was doing was dealing with freedom of information first, and then now we're moving on to privative clauses. So in fact, that might be a good juncture to deal with your question. So privative clauses, what are they? Also known as ouster clauses, because what they do, or what they often purport to do, is oust the jurisdiction of the judiciary to review decisions of the executive. Now, what you need to know about privative clauses is that sometimes they will be effective and sometimes they won't. So just because a law says that the judiciary has no power to review a decision or action of the executive does not mean, as a matter of law, that it can't be reviewed. One of the things that it takes to be a lawyer, and part of what hopefully you learn as a result of studying the law, is not always to take on face value what the executive tell you is the state of affairs through laws, not always to take for granted what the Parliament tell you are the laws, and not always to take on face value what the courts will tell you is the law. And that, just in relation to that latter part, of course, where I'm talking about, there is appeals. It is a daily occurrence that judges get decisions on points of law and, in fact, on points of evidence and fact wrong. They're only human like the rest of us. They have biases and memory lapses and a whole range of different human conditions common to all of us, which ultimately affect the correctness of their decisions. And so part of your job as a lawyer, when you get a first instance decision, even sometimes an appellate decision, an intermediate appellate decision, such as, for example, a single judge of the Supreme Court reviewing a decision of a magistrate, a 3-judge bench of the Supreme Court reviewing a single judge decision of the Supreme Court or a district court, otherwise known as the county court. And you need to know whether or not you need to take that, for instance, to the High Court. Part of being a lawyer is knowing that often what you are told by any branch of government, be it Parliament, Executive or the Judiciary, is not to be taken on face value as settled. Sometimes what you need to be able to do is look beyond what you are told and bring a principled analysis to what appears in front of you to determine whether or not it is correct. Now, Anthony says, how do you know the difference if they can or can't be reviewed? This is where you have to have a strong understanding of the nature of constitutional arrangements, and this is where Peter's question in relation to Section 75 of the Federal Constitution comes into play. So where it might be, let me start firstly where there might be an example of a legitimate privative clause. A legitimate privative clause would commonly arise where a Parliament provides the executive through one of the administrative agencies or a government department the power to make certain factual determinations. Now, those factual determinations might be expressed as being final and binding. Now, where that sort of language appears, you know that generally there's no power of review. That is, there's no power to appeal against that first instance finding. The exception to that, or the obvious circumstance in where that can't be right, for example, would be where a person concerned in making the decision has made it in such a way as to be repugnant to what's expected through the exercise of power. Now, and by what I mean, and to give you an example of where you might find it to be a repugnant process, would be, let's assume that, yeah, Kylie says bad faith, that's excellent. Those are the sorts of things. So if bad faith is brought to the process, or bias, for example, let's assume that I'm a bureaucrat in a licensing agency. Ray says fraud, again, another good example. Let me give you an example how bad faith or fraud might operate, or bias even. Let's say I'm a bureaucrat in a licensing department and a complaint is received from my brother about the hotel that is operating next door to his home. And the complaint, I receive the complaint and I say to myself, well, I can do something about this, I can cancel his license. So I write to the hotelier saying, receive this complaint, considering cancelling your license. So you can see there I'm complying with the fair hearing rule, giving them an opportunity to be heard, or to some extent. Remember, natural justice also requires an impartial hearing, so I'm going to have problems with that part, but I'll go on with my example. So the hotelier responds, comes in and says, well, I don't know anything about this complaint. We always comply with the licensing conditions. We've got security outside that make sure that patrons who are leaving at closing time get directly into cabs and try and keep the noise down. And, you know, we've been in this spot for 10 years. Our neighbours come and go. This particular neighbour's only been there for 12 months. we're endeavouring to do our best, but there are, of course, limitations to what we can do. I receive, as the bureaucrat, that complaint, and I look at it and I say, oh well, I'm not going to worry too much about that, and I'm not going to tell him that this complainant is my brother, so I cancel his licence. Now, the Act might say that my decision is final and binding, by which it means there is no basis for a merits review. So there's no option to go to the NCAT or QCAT and say, we want this decision remade. Whether that sort of privative clause or ouster clause has the effect of denying the judiciary the power to review my decision is another question, and likely to be answered in the circumstances of the example I've just given you as no. Now, the reason, of course, for that is I'm a public official. I have basically sat on a case where I have a vested interest, or at least a bias, in favour of my brother who's the complainant. I've not told the hotelier about that. Let's assume for a minute that my brother also gave me a backhander for cancelling the hotelier's licence. Then we're into the example that, or the issue, Ray hands potentially of fraud. But you can see here that my decision on this particular case is tainted. Now, the legislation which gives me the power to make that determination might say that my decision is final and binding, but the courts will find it very difficult to swallow that a clause such as that ousts their jurisdiction to review where I have clearly sat on a case and decided a case that I should never have. Now, that's a very crude sort of example, but I'm trying to demonstrate through obvious examples the sorts of circumstances where a privative clause won't be effective. Now, there's a further principle that needs to be considered here, and that is the one which Peter also raises about Section 75 of the Constitution, which basically requires, or empowers, I should say, the judiciary to exercise supervision over Commonwealth officials. Now, legislation, for those of you who have done constitutional law, this will be a fairly trite principle, but legislation enacted by the Commonwealth Parliament has to be constitutionally consistent or compliant. So you cannot pass, the Commonwealth cannot pass a law for which it doesn't have powers, and hopefully those of you, most of you will appreciate that the powers of the Federal Parliament to enact laws are prescribed, and they're limited to those powers which were granted to them at Federation. They don't have this power to make laws at large. Now, where the Parliament, in a similar sort of example, let's say it has some licensing power, enacts legislation which says a decision made under this particular Act cannot be reviewed in any way, that's going to be inconsistent, hopefully you will all see, with the power provided by Section 75, subsection little Roman numeral 5 of the Constitution, which provides this power. And some of the cases, for example, the Kirk case, which I think you have been referred to, dealt with that sort of issue in a state circumstance. That is, so what happened is it dealt with the Industrial Relations Commission of New South Wales, a litigant in the Industrial Relations Commission, in fact the Industrial Relations Commission in court session, which is known in New South Wales as the Industrial Court, so it was an OHS prosecution, made a certain determination on what a point of law was. And that determination was made by a full bench. So what that means is 3 or more judges of the Industrial Court sitting together. And what the Industrial Relations Act said was that those determinations could not be reviewed. Now, the party who was aggrieved by the decision, who didn't agree with it, went to the Court of Appeal, in New South Wales and said, we want review of that decision. And then the Court of Appeal in New South Wales said, well, we don't have any power to do that. Our power to review those decisions is ousted by the relevant privative clause. It then went to the High Court, and what the High Court said was, in short, the state Supreme Courts of each state have a supervisory power, too far to say obligation or duty, but the function of a Supreme Court, a superior court of record, is to ensure that the laws of the state are carried into effect in accordance with law. So what the High Court says is it's no answer to the Supreme Court's responsibility to supervise the administration of government in New South Wales to say that the Parliament has ousted their jurisdiction. They have a power to review the decisions of these courts, which cannot be ousted as a matter of the separation of powers and the proper administration of government. You should read the decision in full. It's a similar sort of decision, although the constitutional arrangements in the states are not the same as they are in the federal system. And you don't want to go too much into that because you'll deal with it in constitutional law. But in short, the point is that the superior courts of record, so the High Court in the federal system, and the state courts of the Supreme Courts of the states have a requirement to administer, to supervise the administration of government. So in the federal system, that is reflected in Section 75, which is why Peter raises it. So let me just catch up on where you are. Peter also raises the Hickman principle. Now, the Hickman principle is a very important principle of law. There are, and one that you all need to be familiar with. So the Hickman principle are the sorts of principles like the Hickman principle are the sorts of principles that you would expect to be asked about, for example, in an optional assignment question. In an optional essay in an exam. Now, I'm not saying to you that that is the question which is being asked in this exam paper, but the point I'm trying to make is that it is such a significant area of law that you all need to be familiar with it. And it's dealt with in the notes. Let's pull it up. Now, the point I was just making about the High Court's powers of review and the constitutionality of privative clauses you'll find on page 28 and onwards of the notes, and it starts to get into constitutional principles. You would not be examined on constitutional aspects. All I want you to know for the purposes of an exam is that any attempt to oust the jurisdiction of the High Court to review the decisions of officers would be repugnant to Section 75, little Roman numeral 5 of the Constitution, and to have a look at the cases starting with the Tramways case and on. Again, this is all set out in the notes. You need to sit down and have a look closely at the notes in relation to these issues. But let's see, what is in these notes about the Hickman principle. So the Hickman principle starts on page 47 of the notes. And you can see that there's a short extract on the case from which the Hickman principle gets its name. It's the 1945 70 Commonwealth Law Reports at 598. It's not an extraordinarily long extract, but you need to be aware of the Hickman case and also the post-Hickman decisions which have considered it. Now, before anyone gets too excited about the amount of time I've spent on the Hickman principle in these proceedings, I just want to say something else about the sorts of issues which you might find in an exam. For those of you who have listened to the lectures, and in particular for those of you who have been coming or have been listening to these tutorials, you will understand or you'll appreciate the emphasis which I have been placing on the role of the judicature as the third branch of government to declare what the law is and the state of the law, and to enforce the law through the various remedies that it has. I want you all to be able to articulate the decisions which that sort of language started in, and to be able to discuss how judicial intervention is affected as part of the judicature's responsibilities to supervise the proper arrangements of government. Now, as part of that, of course, you've got the Hickman principle and the role of privative clauses. So you've got the starting point is to be able to have a look at decisions such as Quinn, which I hope you're all familiar with, and to be able to explain how, on the basis of the Attorney General and Quinn, the courts are the judiciary, or the judicature is expected to exercise the power of review and supervision through judicial intervention, and then to be able to go on to explain, and of course Quinn's not the only case. You'll need to have a look, for instance, at Pico Wallsend, which is something we looked at in the early lectures, and is again something you can take something from the fact that these cases are discussed at the beginning of the course, and they also appear very prominently in the material that you've been provided at the end of the course. And why that's significant is that it initially sets up the head of power, or the basis of power, which we're studying in this course, the judicial review, power of judicial review, and ends with the limitations on that power of judicial review. So it sort of presents to you in a nice, two bookends, the middle ground of the course, so the grounds of judicial review. Hold on, John, let me just read your question. Well, so John says, why would Parliament not put an ouster clause in all legislation to stop all decisions being reviewed? Couldn't they do that under the Constitution? That question really turns on its own facts, so there's no, well, the first part of it is, the answer to the first part of it, I think, is this. Don't forget, Parliament are our elected representatives. Hopefully, for the most part, those people who are elected to government, and I don't want to be so naive as to suggest that this is true of all of them, because patently it is not, but hopefully those who rise to the power within Parliament or to lead their respective parties have sufficient learning to appreciate that ousting the power of the judiciary to supervise administrative action is generally a thing which is inconsistent with the rule of law. It's bad for us. What you don't want, you've all heard the expression power corrupts, and absolute power corrupts absolutely. When you give any human being power, at some level it starts to eat away at their compass. So power is exercised capriciously, or it is exercised excessively. Some people, if they've got to make the same decisions over and over, start to not fully think through the implications of decisions, and that's certainly true of people down towards the lower, it's truer of those down towards the lower end of the decision-making tree, such as front-end bureaucrats, than hopefully it is of those towards the upper echelons of the review tree, which hopefully, well, is in most cases the Supreme Court justices and the High Court justices. You expect that latter group of people to sensibly and methodically and carefully and compassionately think through the implications of the way they exercise power, and the decisions, the number of decisions they have to make on a daily basis tend to be much lower than those at the front end of the decision-making tree, which tend to be administrators. So hopefully those who are elected to Parliament as our elected representatives who are responsible for legislation appreciate that giving bureaucrats a power to make unreviewable decisions is a bad thing, as John has just described it, effectively anti-democratic, because it solidifies power in a small number of people that affects a large number of the constituency. So you can imagine that if a single bureaucrat was given the power to cancel driver's license at will, those politicians who had sanctioned that power would probably find themselves out of a job. So there's a degree of self-interest probably involved in the decision-making process, but I'm probably digressing off the point. Could they do that under the Constitution? To some extent, privative clauses are can be effective. Answering when they will be effective is like trying to answer how long is a piece of string. Each case turns on its facts, and what you need to do is have a look at the Hickman case and those which have followed it, to have a look at how the courts have applied it and what approach is generally taken to attempts by the Parliament to oust the jurisdiction of the judiciary. You won't be asked in the exam to tell me whether or not a specific law, I won't be giving you a specific law and saying, is this privative clause effective or not. You may, however, be asked to discuss the role of the judiciary in supervising the executive and the authorities that relate to that sort of exercise of power, and for those students who are aiming for a distinction or a high distinction, not to be able to discuss the Hickman principle and the cases which follow as the last bookend to the nature of judicial power, simply won't be able to reach that sort of level of marks. For those who do understand the role of the judiciary and the limitations on the judiciary and the principles that generally inform those limitations, you'll be in a much stronger position. Let me scan through here. I think I've answered most of the questions. There are other questions that I haven't answered on privative clauses as yet. All right. Now, the privative clauses lecture notes are quite long. There's some 67 pages, which is quite long in terms of the length of some of the other lecture notes that you've had in preceding weeks, but that is because, as I've said, this is the bookend of judicial review. This is the week that says, whilst you've been learning up until now, the circumstances, the fact that there is judicial review and merits review, that you've been learning the sorts of grounds which you can argue in judicial review, here are the limitations to the extent that you can argue it, or here are the circumstances in which Parliament might try to limit that, and here is the approach the courts have taken to whether or not those attempts to limit the power of supervision will be effective. Knowing that bookend is an important part of having an overall understanding of judicial review. And this is, I hope by the time you come to the end of this course, which we're now reaching, you've got an appreciation for how important administrative law is in controlling government action, an aptly named textbook, and how broad the application of administrative law can be to the lives of everyday people. privative clauses is, as I keep saying, the bookend of that power. This is where you look to work out whether or not this very important tool of judicial review is available to your client, and whether or not one of the defences which might be put against you should you start proceedings for judicial review might be a limitation on the court's power to actually hear the case by reason of what the Parliament through legislation has said are the limitations on, or the finality of the decisions which are made by the relevant executive functionary, be it an administrative, be it a minister or a department or a frontline bureaucrat, has to say about the relevant decision under review. Now, if there aren't any more questions on that, a word of advice for next week. You'll see, for those of you who have been on to the Moodle site, that next week I'm holding 2 review sessions. They'll probably be about an hour or 2 in length each, and we won't be covering, well, I'll let you guys drive most of the sessions because they'll be your review sessions, but I'll be trying not to duplicate what we cover in those sessions. So I'm going to try and walk you through proper preparation for the exam in this course, and do that over 4 hours. In preparation for, now the reason that I've set them apart, one's on Tuesday and one's on Friday, is that for those of you who attend on the Tuesday, you'll be able to go away and think in the following 3 days about some of the material we've covered, collect your thoughts, do a bit more reading, do a bit more research, come back on the Friday and we'll work through a few more issues. Now, in preparation for the first review session, what I suggest everybody does is go through the problem questions for each week and have a look, read them if you haven't done them already, and reread them if you have done them. And as we went through those problem questions, some of them built consecutively in the weeks on the problem in the week before. But for the most part, the problem questions dealt with single issues that related to the administrative law issue or topic and subject which we were dealing with in that particular week. Administrative law problems, like all legal problems, tend not to be single issue problems or questions. They tend to be multifaceted, and you should expect exams to be multifaceted. So you wouldn't expect, you all know already that the exam for this course is 2 problem questions and an alternative essay question. The way we've been working through this course, and the reason that 2/3 of the exam are problem questions, is because I've been trying to instruct you on administrative law from a very practical perspective of solving people's problems. When you get to an exam in administrative law, the problem questions will be multifaceted, so they won't simply deal with a single issue. So the point of going back now and rereading those problem questions and sitting down and having a look at the issue that arises, or the issues which could arise, so some of it's going to require you to anticipate or to read between the lines of how that particular problem question could be built on for an exam purpose, will benefit in review session 1 by having done that. Now you'll see in the materials for week 12, I've also included for you an answer guide to problem questions. It is only a guide. You will not get through the exam by rote learning the answers to the problem questions. What the problem questions and the problem answers are designed to do is to try and help you start critically thinking and analysing administrative law problems. And the answers are in fact only guides. So the I think the problem questions, like for weeks 27 and 28, we discussed in week 9, could go either way depending on the facts which weren't contained in them. Simply learning the answers to problem questions 27 and 28 and then rote learning them and then regurgitating them in an exam, should a question of unreasonableness or Wensbury unreasonableness in the exam is not going to get you guys through. What it's designed to do is to have you start thinking about the sorts of things that you would want to be able to raise in an exam. Now, somebody has just said, sorry, one second. Thank you for pointing that out, Jolyn. Apparently the week 12 materials were not visible. I've just made them visible. You'll see 2 Blackboard Collaborate sessions there, which I hope will answer your question, Anthony, about the time. Peter, they hopefully will be recorded. Some of the week's tutorials did not record. I don't have power over that. The best thing to do is to come along, of course, to them if you can make them. If you can't, I will be attempting to record them as I always do for you. But you'll be able to re-listen to them. But you know, when I go through review session 1 and 2, we'll try and raise problem questions and the sorts of issues. You guys will drive this, by the way. This is not a session where you come along with your pen and paper and you write down everything I say and you've got all the answers to the exam. This will be a critical thinking exercise which will hopefully have your brains hardwired for administrative law problem questions, but I'll be getting you guys to do the bulk of the thinking, because I won't be there in your exam to tell you all the answers. Naturally, you guys will be on your own, and so best that I think in these review sessions you start driving the critical thinking. I think my experience so far, and might be a product of the online aspect, is that I do far too much talking in these tutorial sessions, and you guys probably need to do more of the heavy lifting, but that's what we'll be aiming for next week. You will see in the Blackboard review sessions that I think we've said 4 till 6 on the Tuesday and 6 till 8 maybe on the Friday. Can anybody confirm that? Somebody who's had a look at them? Yeah, so sorry, when I say 6 to, it'll be 5 till 7 Queensland time. I'll send out an email anyway clarifying this for you, because I know there's been some confusion. So don't stress too much about it. Just keep Tuesday and Friday afternoon of next week free if you can. Otherwise, tune in to get the recordings at a later stage. Read the problem questions, read the answers, the answer guide, not the answers, the answer guide to the problem questions as you go through them, so that you're clear about the sorts of issues that are going to come up, and start thinking about how some of the sorts of issues which are raised in these problem questions might be built on in such a way as to make available 25 marks each. So how some of these sorts of problem questions or the issues raised in them might be packed into single questions, and the sorts of issues that you might have to cover for a person who comes into with an administrative law problem. And in each of the tutorial sessions and the lectures that I've done for you that have been focused on problems, people's administrative law problems, obviously another good thing to do this weekend, I know it's Australia Day long weekend, but it'll be time well spent if you sit down and you go through those lectures. I've tried to keep them short and sharp to the point for you, so the lectures have been 30 minutes to hone your attention on certain critical aspects, and the tutorials have been very heavily geared towards problems, administrative law problems. Go through those materials together with your notes, have a look at the problem questions, and turn up at the review session ready to tell me how you might answer the types of problems that I might throw out at these review sessions. I know there's going to be a lot of anxiety at this stage. We're reaching the business end of the course, but it's all there for you guys. For anyone who's repeating from last semester, this is a second go at it. The notes are largely the same. In fact, they're effectively the same. The only variance would be amendments for typos. I've kept the materials, as I said, short and sharp for you all, so that you can get across this material from a practical point of view without hours and hours of engagement. If you've gone through the notes for each week and you've been listening to the tutorials and the lectures, you are going to be in a very good position going into this exam. For those of you who haven't already done it, now's your opportunity. You've still got a couple of weeks, which is plenty of time given the succinct way I've tried to present the materials for you, which is perhaps not entirely consistent with this little exam summary I'm giving you at the moment. I'm sorry for that. But I do really want to press upon you the notion that anxieties do run high at this time of year. You have to control those anxieties. You have to focus on the materials. You have to start critically thinking through, based on what you've seen so far, the sorts of problem questions which are likely to arise, or essay questions if you prefer to do that one. I think that's all I really want to say for the purposes of preparing for next week. Any final questions or remarks for next week? Tuesday afternoon and Friday afternoon, be available from 4 if you can. Sorry, Kylie, I missed your question. Who decides whether or not a judicial review is available in any circumstance is the courts. So how these clauses operate is that somebody files a summons seeking judicial review of a particular decision. If the Act contains some sort of ouster clause or privative clause which says these decisions cannot be reviewed, then the courts whose obligation and duty it is to interpret, declare, apply and enforce the law do so. So if it is a legitimate privative clause, the courts would refuse to provide the substantive judicial review relief, and it probably would there be done by way of preliminary hearing, Kylie. If it's not a legitimate privative clause, or one which is ineffective for the purposes of ousting the court's jurisdiction to review whatever the decision is at hand, then the case proceeds to judicial review. By having a look at the, one of the very important things is to realise in the notes we try to give you a introduction to the cases. So by reading it, you get a sense of what the case is about. But to truly understand how the law operates, there is no substitute for actually going into these cases. So the Kirk case that I referred to before, you'll find on the High Court website, you just type in Kirk and K-I-R-K, and you'll see an example of one which got all the way to the High Court, involved in part an attempt to oust the jurisdiction of the New South Wales Court of Appeal to review, and you'll see there that the High Court had some not too kind things to say about the New South Wales Court of Appeal's inclination not to exercise a power of review, and you'll get a sense of exactly how they work in a practical sense, as you will probably also experience by reading at least the first few pages of each of the cases we've cited for you in the judgment. Some of them may not have a procedural aspect. For example, the older cases, particularly those reported, for instance, in the Commonwealth Law Reports, tend to be quite brief. The old reports managed to reduce some of these cases down to 4 or 5 pages. In contemporary reporting, they tend to go on for 20, 30, 40 pages is still a short case. But the advantage of the longer cases is that you get a better sense of the procedural history. Has that answered your question? Are you guys all satisfied with how privative clauses work in a practical sense? Okay, good. Well, it's gone 10 past 8. Katrina, you say to a degree. That's a bit ambiguous. What do you mean to a degree? Okay. Not really sure what to say. You need to catch up on your reading. Usually these sessions, as I said earlier in the course, the best way I think to confront this generally is to scan the notes for each week, get online and listen to the lecture, in which I try to just break down for you the issues which we deal with in each particular week's course. Sorry, in each particular week's content. Then to go back and reread a second reading of the notes and read them in detail, and then come to these lectures to ask questions to fill any gaps you might have. So go to the notes. They're fairly good in terms of being able to distill the complex stuff, and then of course there's reading the text. So that's the last stage in it. Is once you've got a solid appreciation for how the principles in any particular week fit together, you can then read the denser material. That's just my suggestion. Everyone can do it a different way, but Anthony, the case is Kirk and the work cover authority. 2012, I think, or it's a High Court decision of Kirk Holdings and the work cover authority. One of the second party, I think, is the Industrial Court of New South Wales. If you Google those party names, you'll find probably links even to the case and case summaries. For the most part, the case summaries will deal with issues regarding the requirement for prosecutors in industrial prosecutions to plead particulars and the like, but the case went into far more than simply that. It's just that it's mostly cited as a decision that relates to OHS prosecutions. I think, sorry, yeah, the Peter says the exam is open book. This means we can take any books and notes into the exam. Yes, that's my understanding, but I don't set the exam rules. You guys need to go to the school for questions on that. If you can't get answers from the school, let me know and I'll chase them up. But I'm not the authority. I don't get, other than writing the exam, I don't get to have I don't have any say in exactly what conditions and what dates, etc. they go on. That's for others to decide. If you've read and marked up your notes and you've read and marked up the relevant parts of your textbook, and you've got a solid appreciation for how the principles and the mechanics of those principles, of that, how that content works, you'll have no problem with you'll have no difficulty with the problem questions. The essay question, not testing obscure principles of administrative law. What I want to know when you do a sit-down exam is whether or not you have an appreciation for how administrative law fits in fundamentally to as a branch of public law, and how it is an instrument which functions as part of our democracy within the Westminster system. Hopefully you've all found the textbook helpful, and if it's marked up, then you'll be in a good position. Anyway, I'm going around in circles now, I think. The rest of does that textbook is one of a kind, is that meant to mean it's a good textbook, or is that a facetious, sarcastic comment? I'm genuinely interested. I don't want to be assigning you materials which you're not finding helpful. Look, when you're starting out, it is heavy reading sometimes, but that's because you're undergraduate law students coming at administrative law for the first time. Most of you anyway. Some of you might be having a second go at it, but as an undergraduate coming at this particular branch of law is not easy. It's not like doing contract law where it flows in a sort of linear progression from agreement to consideration, and then you move on to questions of breach and damage, etc. This is multifaceted in the sense that you've got to work out exactly what the problem is in terms of identifying that middle ground of course content we covered, such as grounds of review. You've got to work out whether you're in judicial review or merits review, and you've got to be able to understand the difference. So this can be a technical sort of subject, so don't be put off by the fact that there is lots to read and that it can be heavy or difficult. If it wasn't heavy or difficult as undergraduate students, I would be very, very surprised. But there's a reason that not everybody can obtain a law degree, and that's because it requires persistence. You have to sit down and read stuff which might appear sometimes to be pushing the cusp of what human beings can comprehend in a single sitting. But that's the discipline. It's not limited to the study of law. It's also a matter of practicing law, which is common to practice of law. And this is why we're trying to train you on this discipline, because you will confront as practitioners issues or cases which might on their face seem to be beyond your skills, and you've got to persist at researching and getting into the detail. And that's right, it does. It falls into place, as Anthony says, with experience, which is why I'm trying to give you some practical context to the principles that you're reading, so that you can get a sense of how the pieces of the puzzle fit together. All right, folks. Well, let's leave it there. We've been going for an hour and a half, and if you haven't made notes on the sort of steps and techniques that I'm suggesting that you take in order to get the most out of next week, go back and re-listen to this tutorial, and make sure that you're prepared. You're going to have to spend your Australia Day long weekends doing some solid preparation if you want to be able to be confident enough to go into the administrative law exam without too much anxiety, but that is possible. It's basically, though, at this point in the semester going to come down to how much work you've done and how much work you are doing over this weekend. I hope that doesn't put you off too much having an enjoyable Australia Day long weekend, but I'm sure you'll all much rather be prepared and go into an exam without anxiety. Alright guys, have a pleasant weekend. We'll see you on Tuesday. I'm going to stop the recording.